Senator from Utah.
Madam President, I rise to speak today in opposition to the nomination of Caitlin Halligan to be a judge on the U.S. Court of Appeals for the D.C. Circuit. The D.C. Circuit is arguably the most important federal appellate court in our federal judicial system, with primary responsibility to review administrative decisions made by countless federal departments and agencies. It has also served in many instances as a stepping stone for judges who are later appointed to the U.S. Supreme Court. As a result, the Senate has historically very closely scrutinized nominees to the D.C. Circuit. And when evaluating particular nominees, we've also carefully considered the need for additional judges on that court. In July 2006, President Bush nominated an eminently qualified lawyer, Peter Keisler, to fill a seat on the D.C. Circuit. Mr. Keisler is among the very finest attorneys in the country. Because of his non-ideological approach to the law, Mr. Keisler enjoys broad bipartisan support throughout the legal profession. Despite these unassailable legal qualifications, Democratic senators blocked his nomination. He did not receive any floor consideration whatsoever, not even a cloture vote, and his nomination languished in the Judiciary Committee. At the time, a number of Democratic senators sent a letter to the Judiciary Committee chairman arguing that a nominee to the D.C. Circuit, quote, should under no circumstances be considered, much less confirmed, before we first address the very need for that judgeship, the judgeship that he would occupy. These senators specifically argued that the D.C. Circuit's comparatively modest caseload in 2006 simply did not justify the confirmation of an additional judge to that court. 5 years have now passed, and Ms. Halligan has been nominated to that very same seat on the D.C. Circuit. But the court's caseload remains just as minimal as it did then. According to the Administrative Office of U.S. Courts, the D.C. Circuit caseload per judge is approximately 1/4 that of most other federal courts of appeals. In each of the past 2 years, the D.C. Circuit has canceled regularly scheduled argument dates due to lack of pending cases. For several years, the court has experienced a decline in workload in terms of total filings, actions per active judge, and pending appeals. Almost every metric indicates the same direction. Indeed, since 2006, when Democrats blocked Mr. Keisler's nomination, the total number of appeals filed in the D.C. Circuit has decreased by 12%. According to the Democrats' own standards, and particularly when there are judicial emergencies in other courts across the country, now is not the time to confirm another judge to the D.C. Circuit. And it is most certainly not the time for us to consider confirming a controversial nominee with a record of extreme views of the law and the Constitution. Many of my colleagues have discussed these views, so I will limit myself this morning to just one example. In 2003, while serving as Solicitor General of New York, Ms. Halligan approved and signed a legal brief arguing that handgun manufacturers, wholesalers, and retailers should be held liable for criminal actions that individuals commit with those guns. 3 years later, in 2006, Ms. Halligan filed a brief alleging that handgun manufacturers were guilty of creating a public nuisance, that they themselves were guilty of creating a public nuisance. Such an activist approach is both bewildering and flatly inconsistent with the original understanding of the Second Amendment and the rights under the Second Amendment that American citizens enjoy. In conclusion, as measured by the Democrats' own standards and their prior actions, now is not the time to confirm another judge to the D.C. Circuit. And it is certainly not the time to consider such a controversial nominee for that important court. For these reasons, I cannot support Ms. Halligan's nomination and urge my colleagues to oppose her confirmation. Thank you, Madam President. I yield the floor.